morning, everyone. Welcome to the First District Court of Appeals. We have 3 cases that are going to be argued this morning, and we have 3 cases that are submitted. So I will first run through the submitted cases just so that we have that. We've got case number C220192, which is Ijekoli versus Alungbi. Case number C220382, In re Jamal David. C220448, In re DL. And then I get to the 3 cases that we're arguing. The first case to be argued is C220384, Armstrong versus U.S. Bank National Association. Would the attorneys for that case please state your appearances?
Good morning, Your Honor. Andrew Poltrak for the appellant, U.S. Bank.
Thank you.
Good morning, Your Honor. Jonathan Helton for the homeowner, Kenneth Armstrong.
Thank you. And the second case to be argued is C210494, State of Ohio versus Bell.
Eric Gustafson for appellant Marcus Bell, Your Honor.
Good morning, Your Honor. Keith Sauter for the state.
Good morning. And the last case is C220534, In re Adoption of JGS.
Good morning, Your Honor. Mark Epping for the appellee, Carly Schroeder. Ready to proceed this morning, Your Honor.
Good morning. All right. Well, will the parties for the Armstrong case please step forward and we will get started. Yes, and would you like to reserve some rebuttal time?
I would. I'll reserve 3 minutes, please.
Okay. I will try to remember to use the lights on the podium. You'll have, with the yellow light, you'll have a minute left, and the red light is stop.
Okay.
Okay? Whenever you're ready.
Thank you, Your Honors, and may it please the court. My name is Andrew Poltrak, and I'm the attorney representing U.S. Bank National Association as trustee, and there's 2 separate entities here that I want to note. I'm going to get into that in a little bit more detail later in the argument, but first, U.S. Bank as trustee for the Structured Asset Securities Corporation Mortgage Loan Trust 2006-BC1. I'll refer to that as BC1. There's also U.S. Bank as trustee for the Structured Assets Investment Loan Trust 2006-3. You may see that referred to in the pleadings as SALT or 2006-3. We are appealing the trial court's denial of the motion to set aside a default judgment. And summarizing briefly the issues that are presented for review, 1, whether it was abuse of discretion for the court to fail to address our meritorious defense that was raised in the motion. Additionally, we are presenting for this court, and I'm going to spend most of the time this morning addressing the issues related to 60B5 and 60B4. And then additionally, whether the court committed error by adopting the Armstrong's findings of fact and conclusions of law where there was no evidentiary hearing and none were requested. So again, to start, I'm going to focus on 60B5. Now, opposing counsel for Mr. Armstrong contends that U.S. Bank waived its 60B5 arguments. We disagree with that.
What precisely was the 60B argument you made in your motion, 60B5?
Right. So in our motion, I think we've characterized this consistently throughout. There were misrepresentations that were made by the attorneys in representing this was a default judgment, so it's not an instance where it's an adverse party misrepresenting a fact. It was counsel misrepresenting operative facts.
No, I understand that, but what I'm saying is specifically, how did you frame the 60B5 argument to the trial court in your motion?
That's right, and I think that's what it was. The misrepresentations is how we were referring to it.
But is that fraud on the court?
We think the facts here kind of fall under the situation where it's an attorney kind of gaming the system or, the strategy of pursuing the litigation in Ohio, where there's been extensive litigation in Florida previously, paired with these misrepresentations would raise to the level of fraud on the court.
But did you argue to the trial court in that motion that it was fraud on the court?
We didn't use the phrase fraud on the court. And we did not use that in the reply either. I think our reply in rebutting the arguments raised by Mr. Armstrong were consistent in our initial motion and in our reply. I will say that in the reply, we were simply rebutting the arguments that Mr. Armstrong made. He was saying, this is not 60B5, this is not fraud on the court, it's actually 60B3. And so in our reply, we were rebutting that, saying, no, the facts here are unusual, they are extraordinary, this falls under the 60B5 catch-all. Whether it's fraud on the court, or we cited Smith v. Smith, I think, in our original brief, which granted, it reversed a trial court's decision, finding that 60B5 was appropriate. So we did cite that Smith v. Smith case in our opening brief.
And
so that is consistent with what we're arguing here.
So the misrepresentation is you're saying that they did not discuss the loan modification agreement, so that's the fraud, is the failure to bring that up to the court?
So it's a couple different things. So that's one, and we say that is an operative fact. I mean, they unequivocally said the acceleration date was in 2010. That's not accurate. There was a 2013 modification that should have been represented to the court in the motion for default and in the complaint. The complaint was unequivocal on the acceleration date as well. So we're saying that's an operative fact. Additionally, the issue being that Florida law should apply here, not Ohio law, and the attorneys representing Armstrong were intentionally trying to bypass the Florida law by coming to Ohio to benefit from the Ohio statute of limitations.
I guess, I mean, you're suggesting that's nefarious, but I mean, we see dueling litigation in different jurisdictions, not infrequently. I mean, people are trying to gain strategic advantage. I don't think that's fraud on the court.
So agreed, that alone is not. But again, paired with misrepresentations.
And if your client had answered the complaint and then could have engaged and shown the court why it was not appropriate to litigate this case in Ohio.
That's fair. That's fair. We did not learn of this litigation. Our affidavit supported with the motion says that we did not learn of this litigation until 2021 when the Florida suit was filed, which is still ongoing. I checked last week. Those motions for summary judgment are still pending. And so that's right. The parties should be able to litigate in the current action. It's not an excessive burden to allow them to litigate this down there. Whether Florida law or Ohio law governs this. And we think it's very clear here that Florida law would govern, whether you're looking at the restatement, Section 195 or Section 188. Florida law governs this note and mortgage.
Counselor, can I get back to the loan modification?
Of course.
Even though it wasn't explicitly attached, it was referenced in the affidavit in support of the default judgment. I mean, it discussed it. It was he attached the 2014 complaint for foreclosure, and that discussed the 2013 loan modification.
That's correct. That's
so
correct.
I'm not sure how it could be seen as fraud on the court when it was referenced.
The issue is that the default judgment that was entered, and it appears that it was tendered by counsel for the Armstrongs, says the acceleration date on the note was 2010. That's incorrect. That should have been corrected. The motion for default judgment says the acceleration date was 2010. The way that they are identifying that acceleration date is based on a 2010 foreclosure action in Florida. And this is where I identified the two separate entities, BC1 and 2006-3. So in the 2010 foreclosure action, the entity 2006-3 was the named plaintiff. So 2006-3 accelerated the loan in 2010 as part of that foreclosure action. That was resolved through a modification in 2013. So that acceleration date was resolved through the 2013 modification. Now, in the 2014 foreclosure action in Florida, again, the named plaintiff was 2006-3. However, the Armstrongs argued BC1 should have had standing in that case because they executed the modification in 2013. So the Armstrongs' position in Florida was, no, BC1 actually has standing here. BC1 should have filed the foreclosure complaint because they executed the modification. So all of this goes to say that Armstrong's same attorney, Mr. Smith in Florida, argued, no, because of this modification that we're going to introduce to the court, acceleration could not have occurred by 2006-3. We're saying the same thing here, that the Armstrongs took a different position using that 2010 acceleration date that they knew or should have known was not correct. Taking that one step further, the Florida foreclosure case went to trial in 2019. There were some additional proceedings through 2020 while this default judgment was ongoing.
And what was the result of that trial?
The result of the trial was that the court found that the named plaintiff, 2006-3, did not have standing at the time the complaint was filed because of these arguments that were presented.
It was adverse to your client.
I would say it was not an adjudication on the merits. It was a lack of standing.
But that's adverse.
That's correct, and
Yeah,
we say it was resolved in favor of the Armstrongs.
Okay.
That's correct. Again, however, this 2010 acceleration date just is incorrect. The default judgment is inherently incorrect, and now they're using that, and this goes back to the equities. They are using that incorrect default judgment prospectively. I understand there are issues with the definition of prospective, and the federal courts have addressed this extensively. Ohio courts, though, have not, and we look at the Wurzelbacher decision and how they address 60B4. But
Changing conditions, right?
they look at the no longer equitable to enforce the judgment, as opposed to focusing on the prospective application language in Wurzelbacher.
But doesn't it refer to some kind of change in conditions that makes it
subsequent
an
occurrence.
equitable? Okay.
A subsequent occurrence, yes.
So what is the subsequent occurrence that would constitute the requisite change in conditions?
So a couple things. One, informing the court of the 2013 modification, I think, would be a new fact that would change the trial court here in Ohio's analysis. Additionally, the fact that the arms...
But I mean, just so I understand, like, that's your basis for 60B5, because it's a misrepresentation according to you. So, like, how could it also be the basis for the 60B4?
It would be a different fact. It would be a subsequent fact that would be introduced to the court. The changed circumstance here, and again, looking at the Wurzelbach decision, I think this is kind of in line with that. It's a subsequent proceeding that the Armstrongs are taking. They're taking additional action to extend the declaratory judgment, the default judgment from Ohio, to quiet title, to impact the mortgage. So the default judgment only impacted the note. They're using this prospectively to then extend that holding to clear title to their property in Florida.
But that would be foreseeable that would be their next step, right?
I don't think it was foreseeable at the time the default judgment was entered, simply based on our affidavit that we did not have notice of that at the time. But yes, at the time so this goes to our kind of discussion of, was the default judgment executory? And our issue is it was incomplete. At the time that it was entered, there was going to be additional litigation surrounding this property because it only addressed the note. You still had to have litigation surrounding the mortgage itself and title of the property.
Okay. Well, you're at your time if you want to reserve 3 minutes.
I will, thank you.
Okay, thank you.
Thank you, Your Honors. Jonathan Hilton for the homeowner, plaintiff Kenneth Armstrong. May it please the court. We are here in this case because U.S. Bank waited over a year from the entry of final judgment in my client's favor in the declaratory judgment action below. Because U.S. Bank waited for so long to bring this Rule 60B motion, the trial court correctly found that U.S. Bank was precluded and time-barred from raising excusable neglect for its failure to answer the complaint. Also, Rule 60B-2, which is newly discovered evidence, and Rule 60B-3, which is garden variety fraud or misrepresentation or omission of evidence. Instead, U.S. Bank has had no choice here but to try to shoehorn this case into Rule 60B-4, which is a provision that deals with consent decrees, injunctions.
Can I ask you why the litigation was brought in Ohio to begin with, considering that everybody was litigating down in Florida?
Yes, Your Honor. I believe that in this case, the thought was to bring the litigation to U.S. Bank to try to end it here in U.S. Bank's backyard.
But what was wrong with ending it in your client's backyard in Florida?
I believe because the case law in Ohio regarding acceleration was clearer, and as well, I think what's important is that we allege that the note was governed by Ohio law. Ohio and Florida have very different choice of law rules, and because the note says that the note is payable at such place as the note holder may direct, that means that under a case that I've cited in my brief, Baumer versus Dettelbach, which is a 6th district case, that an Ohio court will look to where the note was currently then payable at the time the litigation is brought in order to decide that Ohio law applied. So because our theory of the case was that Ohio law applied, it made sense to bring the case here where there was general jurisdiction over U.S. Bank, where it was easy to serve at its Walnut Street address, and where the Ohio court would be familiar with and apply Ohio's law.
And plus, the statute of limitations was more favorable here, right?
Not necessarily, Your Honor, because the statute of limitations in Florida is 5 years, whereas the statute of limitations in Ohio is 6 years. I do agree that there's some difference in terms of the case law as to when a note is accelerated, but even under Florida law, assuming that either the December 2010 or, as U.S. Bank contends, the 2014 acceleration date, assuming that either one of those is correct, under either Ohio or Florida law, the note would still be beyond the statute of limitations.
Well, U.S. Bank is saying that it's only the 2013 date that is the acceleration date. And you're saying it could be 2010?
Yes, Your Honor. As opposing counsel noted, there were two distinct trusts. And the one trust that attempted to accelerate the note in 2014 is the same trust that would not have had standing and that the Florida court found did not have standing to bring that action. So while opposing counsel relies on a 2014 acceleration date, our contention is that the 2010 date is the better date to use because the trust accelerating the note in 2014 didn't have standing to accelerate it. And one thing that I'll point out is that the trial court was very likely aware of these issues because we did put it into the record at Exhibit G of our May 18th, 2020 affidavit. And what you see is the trial court patiently waiting until the 6-year statute of limitations ran on the August of 2014 acceleration date that U.S. Bank would have alleged had it entered the case. And only after that date passed did the trial court, within about 10 days, enter judgment in my client's favor. So I believe that this is a conscious decision, or at the very least, the record reflects that it wasn't material which date was used.
Even though, so your client, just to understand, used the 2014 date in the Florida litigation and then came to Ohio and used the 2010 date for the acceleration date? Is that what happened?
No, Presiding Judge Krause, in the Florida case, we introduced the 2013 loan modification as a form of impeachment to contradict U.S. Bank's assertion as to which trust had standing to enforce the note. So it was introduced in an attempt to show that U.S. Bank's records were incomplete and that Wells Fargo's records were incomplete. So that was the purpose of the introduction of that evidence, and we didn't introduce the 2013 loan modification in order to show that it was an enforceable document and that we were recognizing its terms.
Okay.
Moving to Rule 60b-4 and the Wurzelbacher issue. Wurzelbacher is very different from this case because, as we have explained in our brief, Rule 60b-4 is intended to cover consent decrees, long-term injunctions, and court orders that require continuous court supervision. In the Wurzelbacher case, what you saw is a probate court that had the power to revisit a consent jury verdict entered by the parties that dealt with the validity of a will. The probate court in that case was tasked with overseeing the administration of an estate, so it was overseeing the continuous interactions among the parties, including several third-party minors who were beneficiaries. And the court had a duty to continue supervising those interactions, for instance, by relying on the will to appoint an executor and to make distributions, order accountings, and so on. Additionally, there was an agreement between the parties in the Wurzelbacher case where, and I quote the language of the case, they mutually understood, unquote, that if an unforeseen event arose in the future and their settlement agreement was not going to be upheld, then they would jointly move in order to vacate the judgment. And that's exactly what happened. The trial court in that case did come to a conclusion later on that was unexpected, that one of the parties, as the executor of the estate, didn't have all of the requisite consents of the third-party minors to enter into the settlement agreement, and so the settlement agreement was void. And under those circumstances, where there's a consent judgment and continuing court supervision of the parties, then it was appropriate for the trial court to use Rule 60b-4 to vacate that judgment. It was part of an ongoing settlement that had not yet been consummated. The facts here couldn't be more different. In this case, we have a final adjudication on the note of the rights of the parties that looks only to the past actions of those parties. The fact that my client is in Florida using that declaratory judgment in order to remove a now unlawful lien from his home is simply something that was contemplated by the original declaratory judgment, and it isn't an unforeseen circumstance. There also has not been any sort of change of circumstances that has been alleged by U.S. Bank. Moving to the Rule 60b-5 issue, as for attorney fraud, a fraud on the court theory requires something more than an attorney committing what is a potential legal error, and it requires even something more than mere garden variety fraud, which is categorized under Rule 60b-3. In a Rule 60b-5 fraud on the court case, you have to have something that causes a breakdown of the judicial machinery. And this goes to Judge Bergeron's point earlier about what is a fraud on the court. Well, in the Colson case, the Ohio Supreme Court looked at a case of an attorney who had misrepresented to the judge which party he represented in a divorce settlement. The attorney claimed to represent the wife, but in fact did not. The adversarial system is not designed to catch something like that. There is simply not a good mechanism to catch an attorney lying about what party they represent. That would involve a change in the rules of evidence and the rules of procedure to allow for discovery of, and it would raise an issue in every case of whether parties or attorneys are being truthful about who they represent. And so the Ohio Supreme Court correctly concluded, after noting the attorney had violated many of the then applicable ethics canons and had resigned from the practice of law, that that was an example of fraud on the court under Rule 60b-5. In this case, U.S. Bank at best has alleged Rule 60b-3. I don't think that it has even gotten operative facts into its opening brief on that issue because, as Judge Bach noted, we did put the 2014 foreclosure complaint into the record, and it would appear from the timing of the judge's decision that the judge considered it in this case. If there are no further questions.
Just so I understand that, you advanced the argument to the court, and your whole case was based on an acceleration date of 2010, right?
That's correct, Your Honor.
Okay. And are you saying that arguably under Ohio law, that could in fact be the acceleration date?
I believe that it is the acceleration date, Your Honor, because the note was not accelerated by the proper party. U.S. Bank lost the foreclosure case that it brought on that 2013 loan modification. But regardless, it isn't relevant to the issue and it isn't material as to whether the statute of limitations has passed. Because a 6-year period did elapse based on either the 2014 date or the 2010 date.
Okay.
And that's from when the trial court rendered its decision, not from when the complaint was filed.
From final judgment. So there 6 years elapsed from the time that U.S. Bank filed the 2014 foreclosure, which purported to accelerate the note based on the 2013 loan modification. And that 6-year period expired in early August of 2020. The trial court's judgment in this case was entered on August 13th of 2020 after that 6-year statute of limitations had passed. So I believe that also goes to whether the attorney below committed any kind of material misrepresentation, because we would simply state that it's not material on the facts of this case.
Basically that it was harmless.
If there was a mistake of law, it was harmless. But I would further argue that under this court's holding in Fontaine versus Sandhu from 2021, even a mistake of law doesn't give rise to Rule 60b-5. The adversarial system is designed to catch any mistakes of fact or law. And under the First State Bank case that I cite, it was U.S. Bank's burden to introduce the loan modification if it wanted to make a statute of limitations argument based on that. U.S. Bank didn't defend the case, even though it received even though it was mailed a copy of the final judgment by the clerk, that's TD10 at 2. It didn't choose at that time to take an appeal, although everything that it needed was in the record.
Well, I mean, that's what I'm trying to figure out is if this was just a mistake or if this was an intentional misrepresentation, and that would be if the law was very, very clear that 2010 could not possibly be the acceleration date. So I guess what I'm gathering from your argument is that there is some sort of argument that it could be.
Yes. So the argument for the 2010 acceleration date is that the party that accelerated the note in 2010 did have standing to do so, but the party that then attempted to accelerate the note in 2014 did not have standing to do so.
Okay.
And you named both of those parties in this case, right?
We only named U.S. Bank for BC1, I believe, or BCI1, because according to the Florida court decision, that is the entity that is the note holder.
Well, I don't have the complaint in front of me, but their brief says it's brought on behalf of both of them. Is that incorrect?
I would defer to what's ever in the briefing then. It might be my mistake.
Okay.
If there are no further questions.
No, thank you very much.
Thank you, Your Honors.
Mr. Polarak, you have three minutes.
Thank you, and may it please the court. Yes, BC 1 and 2006-3 were both named in the complaint, and actually in paragraph 8 of the complaint, interestingly, it's just Mr. Armstrong, not Mr. and Mrs. Armstrong who filed the complaint, but Mr. Armstrong says, upon information and belief, BC 1 is the holder of the note. So they knew that fact was disputed. They anticipated, had U.S. Bank made an appearance here, that would be disputed as to who was actually the holder of the note here. On 60B5, talking about protecting the integrity of the system, this was a default judgment. I think similarly to some of the considerations that were discussed a moment ago, the adversarial system is not necessarily set up to protect errors on a default judgment. Particularly, this is during COVID-19 time, August 2020. Was there a hearing on this default judgment? What was the court looking at? So there are considerations there. Opposing counsel mentioned the Fontaine versus Sandhu decision, which we looked at. That case is distinguishable because there were clearly legal arguments that were raised in that case as far as whether it raised the level of fraud on the court. Here, we're talking about operative facts, not legal arguments. Looking at the default judgment, it says the acceleration date was December, or was in 2010. Sorry, I just had that in front of me. So the final judgment said the note dated March 17th, 2006, as attached to the complaint, is unenforceable as a result of the expiration of the statute of limitations. The note has been accelerated since December 6, 2010. No monthly payments have been due on the loan since December 6, 2010. Those are operative facts that are incorrect because of the 2013 modification.
Well, they're saying that they have a legal theory about why the acceleration date is 2010. So if that's the case, how can that be a fraud on the court?
Right, so 2 points there, and I think this was just highlighted. The loan modification was in the name of BC1. Their position is that BC1 should have been the entity to accelerate the mortgage. The 2010 date is based on an acceleration by 2006-3. So I think that's incorrect. Two, Mr. Smith, who is representing the Armstrongs in Florida and in Ohio, withdrew as soon as we filed our motion to set aside the default judgment. So he withdrew from this case and has not, been able to explain his logic to the courts. So I think all of this is second-hand explaining what the reasoning was now.
Okay. Thank you.
Thank you.
Thank you both for your arguments this morning. We will take the case under submission and issue a timely decision. The next case to be argued is State versus Bell. Mr. Gustafson, would you like to reserve some time for rebuttal?
3 minutes, Your Honor.
3 minutes, okay. Whenever you're
Please,
ready.
the court, I'm Derek Gustafson. I represent the appellant, Marcus Bell. We believe that there's 4 issues in this matter in terms of failures by counsel, which in and of themselves would justify reversal in this matter. They are the failure to investigate competence, the failure to use professional judgment in the exercise of preemptory challenges, or the failure to exercise preemptory challenges, the failure to call Dr. Wiseman in order to flush out the issue of PTSD and how that would affect Mr. Bell and his perception of danger and his need to use self-defense, and then the jury's instructions themselves. With respect to competence, The competence reports are there as court's exhibits, so.
Well, and I guess just a threshold question is, I realize this is ineffective assistance and this is direct review, and a lot of these seem to be more suited for post-conviction. So can you focus on like what specifically is in the record that shows there is sufficient error for us to recognize it on direct review?
Sure. So within Court's Exhibit 1, there's a bunch of jail notes of things that are happening in jail. Now, bear in mind that there was a trial. It was started, Bell was disruptive, a mistrial was declared. He was declared incompetent a second time. So then he's again made better. And now we're getting ready to start. So we have a trial date in October of the fall, in July, June, July. He's hearing voices in the jail. He's referred for suicide watch. And these are all in the Court's Exhibit 1. There's a whole slew of them from the sheriff. Secondly, Wiseman's report, which was a report done for the initial competence review, opined that Bell could not be restored. So there was a factual issue there whether he was even should have been attempted to be restored. And here we have a second incidence where Bell again is disruptive at the first trial, and we can't go on, and there's a mistrial declared, which is proof that Wiseman may be right. So you have that, and in fact, the reason for Bell being incompetent in the first place by everybody is his inability to assist counsel and his inability to conduct himself appropriately in court. So we have that issue recurring, and we have Wiseman, who's not a court clinic personnel, but rather a defendant's own expert. So we have our own person to call in here and say, hey, we want to review. So that's the reason we think that there's an issue about competence that wasn't properly investigated. All of those things are in the record. Wiseman's report is Court's Exhibit 4. And the state in their brief incorrectly stated that Wiseman's report is not part of the record. It is. It's Court's Exhibit 4. So that is all in the
What was the date of that report?
I have it in my file.
That's okay.
I'll pull it out, but I take that back. I have the date of that report in a footnote in the brief.
Oh, I see it.
Yeah.
19,
Yeah.
July 19th.
So, with respect to the voir dire, State versus Bates is a recent case. The failure to question and remove biased jurors is ineffective assistance. And while Bates dealt with race, they did note within the opinion that actual bias is present when a juror states they can't be fair due to law enforcement bias. Juror number 4 responded in their questionnaire, which is again part of the Court's exhibits, that she has law enforcement in her background and she can't be fair due to law enforcement.
Well, counsel, I was under the impression that the trial court, or that this juror was rehabilitated.
Okay. As trial counsel, you do things. So yes, it was rehabilitated in the sense that the state let her through. Well, you've got law enforcement in your background, but you can be fair, can't you? Well, okay, we're leading her to say, I want to be fair. Natural reaction of people say, yeah, I can be fair. Okay? So yes, that was done in terms of that. Well, why was that done? Well, trial counsel did that to avoid a challenge for cause. Because at that point, it's difficult to sustain the challenge for cause, even though she's told you who she is in her questionnaire. Did defense counsel follow up at all? No. No questions at all. So we still have that there. And as I pointed out in the ABA models for trials, which is a standard to be used in deciding ineffective, one of the things they say is that what are preempts for? Preempts are for bias evidence by jurors which does not raise to the level of a challenge for cause and may be so rooted in fact or rooted in their mind that the juror doesn't even know they have it. So she's a perfect example of why you would use a preempt there.
No, wasn't there, didn't the defendant not want counsel to use additional
And that's
be
another.
satisfied with the jury as constituted or something?
And that kind of goes to the state's argument that all of these are tactical choices. That's a tactical choice. Well, why is a defendant bound by a tactical choice? Well, because they've got someone who's got education, training, and experience. And based upon those three things, they're making the best decision for that client. That's a tactical choice. And that's the rationale why they should be bound by that. But what if a defense counsel says, you know what, I don't care about this guy. Do what you want. Well, he's not exercising professional judgment. That's what makes the tactical choice binding. So when counsel stands up at page 435 of the transcript and says, I'm not going to exercise these 3 preempts because Bell's told me not to, there's no professional judgment being exercised there. It's as if he's abandoned the client right then and there. And a fair jury is what it's all about. If we don't have a fair jury, everything else that comes after that is for naught. So, and it's not only just that juror. Jurors 15 and 17, in their response to the state's question, said that the defendant, or there would need to be a justification for self-defense, clearly showing we're placing that burden on the defendant. Well, that's not the law. Law is state has to disprove it. Counsel did not talk about that at all in voir dire. In fact, in voir dire, counsel never asked the jury that they had to look at it from defendant's view, didn't talk about false belief would be good enough, which is really critical here. Duty to retreat didn't discuss how a prior assault would color the defendant's view of whether he's facing threat or needed to defend himself, and didn't discuss the duty of the state to disprove self-defense. All key elements to get the jury to look at it.
I mean, that was
those.
ultimately, at least on the legal standard, that was ultimately came across in the instructions to the jury from the court, and then there was argument about that in closing arguments.
Well, actually, no. Those same issues were not raised in closing argument by counsel. You're correct that they're in the instruction because they're part of the law.
Right.
But, the horse is out of the barn, in my opinion, as trial counsel, if we're not talking about those things in voir dire, if we're not talking about them in opening, we're not bringing them to life through either direct or cross, and then bringing them to life again in opening.
But this is your disagreement with the fact that maybe this voir dire wasn't exactly an example of how to do voir dire in a criminal case. But, aren't we limited to, in looking at this, whether the record shows that there was some sort of biased juror?
Well, juror 4 is biased.
The law enforcement juror.
Yes.
Right. So the issue of not talking to them about self-defense, that's your problem with how voir dire was conducted. But really, for our purposes, when we're looking at the Bates case, we have to look at whether or not a biased juror actually got on the jury.
Well, according to the language of Bates, and it's in there, the law enforcement juror would fit the definition of a juror with actual bias. So while the other two may not, I think they still should have been removed. They don't fit that same definition that's in Bates of actual bias.
No, was Bates, I thought the issue in Bates was that there was stuff on a jury questionnaire, but the juror was never even asked about it.
Correct.
So this is a little different because the juror was asked if they could be fair and impartial, and they said yes.
Well, that's, again, but not by defense counsel. And when you have if
Does it matter who asks? I mean, if the judge asks?
I think it does, but it's part of the failure to exercise the preempts, though. Because if he was exercising the preempts based upon the state rehabilitated the juror and he thought the juror was okay based upon that, then that would be a tactical choice because he's using his training, his education experience.
But you also have to look at who's coming next, right? If you're exercising your preempts and then you get you're going to run out at some point. So you have to kind of decide who's better. I mean, you look down the line.
Again, that would be valid if the record was clear that he was exercising the preempts in his professional judgment.
Well,
I'm not going
we don't have that on this record.
No, we do. He stands up at 4:35 and says, "I've been instructed not to use the preempts, so I'm not exercising." He stands up and says that in open court. 4:35.
What if he just stood up and just said, "I'm not exercising my preempts," and he doesn't explain why?
Then the record would not demonstrate that he was not exercising his professional judgment, and you would be accurate.
Okay, so your argument is based on the fact that because his client told him not to, and he probably had a good reason.
This is not a client decision. This is a decision you consult with the client, but not defer.
I understand your argument.
Yeah. So, and then the next would be the failure to present Wiseman's testimony. And State versus Brunch is a very recent case where the Supreme Court indicated that ineffective assistance of counsel can be shown where on an issue which would need to be presented by expert testimony is not presented when you have an expert. And we had an expert, Dr. Wiseman. He opined that Bell suffered from PTSD. Within the report is an indication that people who suffer from PTSD have an exaggerated startle response, that they're prone to respond in ways to violence in a different way. So getting the jury to see this through Bell's eyes, this evidence was critical to present, and it was not presented at all. There's evidence in the record that there was a threat to Bell. Kelly Sr. testified at 5:57 that his son offered to fight Bell. Bell himself testified that Kelly Jr. swung on another individual, Westside, who did not testify, but that's how he was identified in the record, as a person named Westside. I assume that's a nickname. That's at 7:89. And Bell also testified that Sr. said that after he was swung on that, hey, we're not there for him, we're here for him, meaning Bell. So there was a direct threat to Bell, as in the record, and Wiseman's testimony would be crucial to flesh that out. So I'd like to reserve my remaining time at this time.
Okay.
Good morning, Your Honors.
Good morning.
May it please the court. I don't have a lot to add to Ms. Steers' brief. I think she did a good job of covering everything. As to the competency issue, I would just note that the testimony, or actually the reports of the psychologists that are in the record indicates that at least a portion of his disruptiveness was volitional, and I think that that's borne out by the record. The trial judge had a stern talking to before the second trial, indicating that if there were more outbursts that he would have to take drastic measures, and after that there were no more disruptions. Apparently the defendant understood those admonitions and respected the court's authority. He was able to testify without incident. There was no indication that there were any other disruptions that occurred during the trial, and I would just say that the competency issue is the arguments are without merit. As to the peremptory challenges, there's no indication that the trial counsel abandoned his client in this case. I think when you look at the context of the statement that he made about the peremptory challenges, it was that he wanted to. It seemed that he wanted to give his client some measure of control over the proceedings, and there's no indication that if he had seen some sort of red flag in these jurors that he wouldn't have exercised his ability to kick the jurors off. None of the jurors were so alarmingly biased that it would seem that he abandoned his role of protecting his client.
Is there a concern that if he is too deferential to his client on this question, that would fall below the standard for appropriate counsel's conduct?
I suppose, Your Honor, if there were more indication in the questionnaires and in the voir dire that these jurors were actually biased, that there was an indication that somebody.
Well, I mean, the one juror that opposing counsel emphasizes did indicate she was biased in favor of law enforcement, which is.
Yeah, she indicated she had a favorable view toward law enforcement, but I think as it was fleshed out, the bottom line and where we end is that she did say that she thought that she could render a fair and honest verdict, and I don't think there's any indication that was false or that it had any impact on the verdict in this case. The PTSD issue, I think the one thing to look at in this case is that in terms of whether there's a fear of imminent harm in terms of the self-defense statute, there's an objective component to that, and I don't think Dr. Wiseman's report or opinion goes to that in this case. I don't think it could be shown that there was any objective fear on the part of the defendant in this case that there was a fear of imminent harm, that was reasonable, I guess is what I'm trying to say. So there's no showing that the absence of Dr. Wiseman's report from the evidence would have.
Well, I thought there was testimony that the victim said he was going to fight him.
There may have been some discussion of fighting the defendant and fighting Westside, but there were no overt threats. Person wasn't armed. Kelly Jr. was not armed. There was no indication that really he made any kind of a overt movement toward the defendant in this case. Any aggression seemed to be directed toward Westside, the person who was the bystander in this case.
When you talk about the objective component of a reasonable person, is it any reasonable person, or is it a reasonable person who suffers from PTSD from having been shot before?
Yeah, well, I think the PTSD would go to the honestness, the honesty of the reasonable fear. I guess you could make that argument, but I think in this case there was just so little provocation, so little threat directed toward the defendant himself that even with the PTSD testimony or evidence, I can't see that it would have made any difference in the verdict in this case.
Well, it goes to the credibility, right? So the defendant testified in this case, right?
He did.
Yeah, and he said that he was scared and he had been shot before.
Yeah, and I think so, and I think that the jury could have taken that into consideration in determining whether he actually had the subjective fear.
But they would have to have believed him, and then if you add to that an expert who has diagnosed him, that really kind of helps to solidify his testimony.
It wouldn't have hurt.
It wouldn't have hurt.
But I don't know that it tipped the scales in this case when there was so little evidence that there was any aggression leveled toward the defendant in this case. In terms of the jury instructions, I don't see any error in this. The defendant doesn't argue with the correctness of the instructions in his brief. The trial court had to instruct the jury as to every element of self-defense. It couldn't leave out the part where it was fault. Otherwise, that would have been an improper and incomplete jury instruction.
The trial court just followed the OJI, right?
It did.
Yeah.
It was by the book jury instructions. I think what it boils down to is there are a lot of things that maybe don't appear in the record that, as Judge Bergeron indicated, might be more proper for a post-conviction petition. But in terms of what is in the record, I think it's a lot of armchair quarterbacking. I don't mean to be disrespectful, but it's that kind of second guessing at this point, and I just don't think there's enough here to indicate that the verdict was unfair. Unless there are questions.
All right, thank you so much.
Thanks.
You actually have about 3.5 minutes.
With respect to the PTSD, while Bell testified that he was shot and was afraid, he didn't actually testify that he was diagnosed with post-traumatic stress syndrome, and obviously didn't testify as to all the features of that. So that's why Wiseman's testimony would be so crucial on the issue. In addition to corroborating Bell's testimony that he actually had the condition and actually had he shot. That was one of the other things we mentioned. We don't know what they were out by medical records, but according to Bell, he did a couple months at university and then a couple more months at Drake at rehabilitation, had to learn to walk again, eat again, and those things. None of those medical records were brought in evidence in. So
Well, again, wouldn't that be more appropriate then for a post-conviction petition?
That would, but one of the things I did in this brief was to raise all the different things that counsel didn't do, because the state says it's all tactical choices. Well, tactical choice is a trade-off, right? If we stipulate that my client has a prior conviction, we do that not so that they won't highlight that prior conviction in the trial and get more prejudice by that. That was a tactical choice made by counsel. So all these things that we've raised, what's the tactical benefit? What's the tactical benefit of not discussing things in voir dire? What's the tactical benefit of effectively waiving opening statement by saying, you've heard he shot this guy, I want you to think why he shot him. When in fact, now that you've conceded that he shot him, your only real way to have any success for your client is to go the self-defense route, but yet you don't talk about it in an opening statement. How's that a tactical choice? There's no tactical benefit there. So all these things demonstrate not that these are tactical choices, but these are failures throughout, from start to finish, everywhere we go. The at-fault instruction, I don't believe that they're entitled to that instruction. You have to think of it this way. There's elements that the state can prove to disprove self-defense. They could prove Bell was at fault. They could prove he used excessive force. They could prove he violated a duty to treat or some way. Well, if there's no evidence that he was at fault, why should they be able to get the jury to speculate whether he's at fault? There wasn't any. The case law says he has to do something which would cause the victim to attack him. They argued that Kelly's left. That is a clear, nobody disputes that. They then came back and pressed the issue. How is their return to press the issue with Bell's fault? It's not. It's their fault. They're the aggressors in the matter. Had they never returned, we'd never be here.
That was argued, right?
Not particularly, no.
In closing?
In fact, the state argued in close that he was at fault somehow because of the initial dispute between them about whether he'd shake their hands or not.
So, okay, so the state argued that the fault came from the initial dispute.
Correct.
And you're saying defense should have said, well, no, you don't look at the initial dispute. But then still, how is that a mistake for the judge to instruct on fault when the state actually, their theory was that he was at fault?
Because there's no evidence of it. Because the case law that talks about at fault, which I admit is few and far between, I think there's 3 cases total. And the most recent one we found, we actually cited in the brief. In that case, they talk about you must provoke the action of the victim. And so how is this provoke the action of the victim? What Bell did, you won't shake my hand, is done and over with. The victim left. So that was done and over with. So there's nothing there. The instruction on retreat's also incomplete because their jury was instructed that he doesn't have a duty to retreat if he's in a place where he's lawfully entitled to be. Well, this happened on the sidewalk on the street. He's entitled to be there. So there's nothing to tell them whether you had a duty to retreat or not. As we stand here today, we don't know why the jury decided to find that the state had disproved self-defense. Which element it was, we'll never know. But we know that they were allowed to argue both of these issues, and the instructions, while coming out of OGI, don't fit the facts, and the instruction on retreat was incomplete in that respect, that they're not given enough there. So again, the jury was just kind of left to do whatever it is they felt they would do. So for all those reasons, we don't think Bell received a fair trial, and we'd ask for reversal.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. All right, our last case today is in re adoption of JGS. Mr. Whitfield, do you want to reserve some time for rebuttal? 4 minutes? Okay. Whenever you're ready.
Good morning, Your Honors. May it please the Court, my name is James Whitfield. I have the privilege of representing the appellant, Mr. Arnold. I don't think that there's a lot of factual dispute in this case. I think the facts are pretty clear. My client and his parenting partner had a child. They were young. They weren't able to take care of that child. And Ms. Schroeder, Mr. Epley's client, she stepped up and she took care of Julian. She's taken good care of Julian for, I think, over 7 years now.
Please don't use the names of the...
I'm sorry. My
Thank you.
apologies. But this child has been cared for by petitioner, and that's not in dispute. It's also in dispute that the reason my client couldn't take care of his child, he was dealing with some substance abuse issues. Those issues led to incarceration. They led to an inability to take care of his child. They led to bad decisions that he made over the years. It's undisputed that he and the mother are in a much better place than they were at the time that this child was granted, that the child went under the custody and care of petitioner. He's changed his life tremendously with the help of his father, who's here today, with the help of other family members and some support groups that he sought out over the years. He cleaned himself up. And, you know, according to the brief I read, the opposing brief, and some of the arguments that have been made throughout this case, maybe he took too long to clean himself up. Maybe he didn't do enough. But that's not what the law requires. He made the decision to clean himself up, to get in a place where he felt he would be a benefit to his son, where he could add some things to his son, where he could supplement his son's lifestyle, or his son's safety, his son's care. He got to that point. He tried to find his son. He tried to talk to his son. He was denied. He was thwarted. He was ridiculed. He was verbally attacked. And he said, I'm not going to do that. But he didn't give up on his son. Then he went out and put himself on child support so he could at least support his son financially. And as we see here today, you know, he's still under child support obligation, and he's dealing with things that stem from that. But that's not the actions of someone who is abandoning their child, who doesn't want to be in their child's life. And I don't think that's another disputed fact. I think it's clear from the decisions that both these parents now want to be in their sons' lives. And I think it's also clear that both these parents, if allowed to be in their sons' lives, would be a benefit to their son's life. And that doesn't negate or contradict anything that the petitioner for this adoption has done for the child. Again, his thing is to supplement, not replace. And when you start to look at those facts, and you put those facts into the best interest factors, I think it's clear that, you know, the
Well,
decision.
what specifically on the best interest factors, which are the ones that you think are the strongest for your client's perspective that would show that the trial court erred?
At least half, Your Honor. I know in the opposing brief, they said that we only focused on the least detrimental available alternative, which is a big factor in this case, because granting adoption is just simply not the least detrimental available alternative. What would happen, or what happens when this adoption goes through, are the parental rights are terminated. The child loses his legal right to his parents, as well as the parents losing their right to their child. An alternative that could exist is things to remain the way it has been for the last 6 to 7 years. Petitioner got custody in 2016. The child's been under her care since before she received custody in 2016. In a stable environment, in a safe environment, in an environment where he has done well. Again, that's undisputed. So the least detrimental available option is to leave things the way that they are.
But I mean, for how long? I mean, I guess that's the question. Like, is that just in perpetuity or what?
I mean, until he's emancipated legally, which would be either 18 or depending on, you know, what's going on if he's 19 and still in school.
Wasn't there testimony from the child that he was concerned that the adoption wouldn't go through?
There was.
So why would just leaving it unsettled, why would that be least detrimental?
Because there have been protections. The Ohio statute has already set up protections to make sure that his concerns don't come to fruition. His concerns arise not from the care that he's been given. His concerns arise from, presumably, this wasn't in a record, but some information he was provided to by a petitioner. Otherwise, he wouldn't have those concerns. Because part of the argument is that mom and dad have not been around. So the lack of stability, his fear that he might lose the family he knows, that wouldn't be in his head unless it was placed there.
Well,
to go back.
Well, if that's not on the record, first of all, that doesn't exist. But secondly, if this child is concerned about permanency and having that stability, I mean, it wasn't necessarily put in his head.
Respectfully, it had to be placed in his head because all he knows is what he knows. And he's been in the same residence since he was very young, 3 or 4 years old. That's what he knows. He's been stable. He's been consistent. He's been in that residence the whole time. The laws that protect that stability and is a lower or a less detrimental available option are the custody statutes.
Well, he doesn't know that. He just
Right.
knows that who he calls mom, who he calls his sisters, and that he wants to be, apparently, according to what he explained to the judge, that he wants to be part of that family, like a permanent part of that family.
And there's no threat that he would be removed from that. Like the things that you just described, I agree with. That's what he wants and that's what he has. And that's what he will continue to have. But he won't have the benefit of his parents, or he won't have the benefit or the knowledge that there are other sides to him. He's a young man. He's going to grow up. He's 9, 10 years old at this point. So as he grows and develops, he knows that he may not know, he may know things, but there's a certain part of him that he needs to know.
He could
Certain
make that
side of him.
choice at some point, right?
I'm sorry.
He could make that choice if he wanted to
He could make
later
that
in
choice
life.
once he's 18.
Yeah.
I mean, he could probably make that choice as a practical matter before he's 18. We understand, that. However, like I said, the custody petition and the custody statutes prevent what I think the court is alluding to in the instability that we talk about. Because the parents can't just come in and take this child from the residence that he calls home, from his family, those family members that you could describe. That doesn't happen. There has to be a change in circumstance. That change of circumstance isn't with my parents or with my client or the mom. They've improved themselves, but they can't just come in and say, hey, we're all better now. We're coming to take you.
They could file for change in circumstances, right?
They could file, but only change of circumstance, and again, the law is set up to protect, the change of circumstance would have to be with the custodian. So if something were to happen to the custodian and she could no longer provide care or something to that effect, then the parents could come in and possibly, have a better chance to get custody. Just to come in and say, hey, I'm all better, I'm clean and sober, I've been doing great for the last 4 or 5 years, and now I want custody, that's not gonna happen. But they can come in and say, hey, I've been doing better, I've been doing great for the last 4 or 5 years, I wanna come in and I wanna get to know my son. I want to teach you about, for my client's particular case, a whole side of your family, a whole side of your DNA that may not get addressed any other way. I want to be that father figure. There's been testimony that the child has a great home, a great environment. I think I saw a grandfather here, petitioner's like grandfather here earlier, but he's only got one father. He doesn't have a father figure in his home. At least we didn't hear about that, if he does, but he has a father who's stepped up and who's willing to do what he needs to do. And as the court found in MRP, in the case MRP is cited on our brief, the least detrimental option is to keep this child in the same situation where he's stable, where he's safe, where he's provided for. And if you can supplement that, then supplement that. Because there's nothing in the record that would indicate that to deny this adoption would cause him any harm at all. There's nothing there. It's never been testified to.
Well, the least detrimental option is just one factor to look at.
That's just one factor to look at.
So this is a tough standard because you have to show the court abused its discretion. So talk to us about other factors that the court just got completely wrong.
Well, related to that factor, you jump to number 5, whether the child will enter into a more stable and permanent family relationship. And I hear the court, and I've heard counsel stated over the while, well, the child has concerns about possibly parents coming in and getting custody. But that's not going to happen. That's not that realistic. The child's going to be in the same exact position that he's been in for the last 6 to 7 years.
But how does that go against his action? He does have these concerns. Whether the concerns are true or not, this is you're looking at the impact on this child and his constant fear of being taken away from this family. Whether it's a reasonable fear or not, he's expressed that he has such a fear. Isn't that something the court can look at?
The court can look at that, but again, the court has to look at the source. I don't know if it's a constant fear, because over the last 4 or 5 years, it wasn't ever, I have no idea if the child was talking about 4 years ago, hey, my mom and daddy, whoever they are they gonna come take me? That wasn't a constant fear. This arose, I'm presuming, after this court case stepped up, when the parents said, okay, we want to do something. We want to do some things. We want to be involved. So the situation that the child's going to grow up in or change, granting this adoption doesn't change anything other than terminating those rights, other than cutting off possible resources from him, other than cutting off some additional love, essentially. But I can get back to the factors.
Just to let you know, if you want to reserve 4 minutes, you are at your
About 4
time.
minutes? Okay, that's fine. I'll reserve the 4 minutes.
You're going to reserve? Okay, then you're at your time.
All right, thank you.
Thank you.
Good morning to this honorable court. Mark Epping on behalf of the appellee, Carly Schroeder. Before I begin my arguments, I just want to make one quick correction to the second argument that we had presented in our brief. The correct statute is 3107.161, not 162, and all of the applicable B1, B2, B3s are under 3107.161, not 162, just for clarification. Opposing counsel stated in this opening that Mr. Arnold made bad decisions. There's no debate about that. But the reason that we're here today on the issue of permanency of adoption is not because of the decisions that Mr. Arnold made in the past. It was the lack of decisions that Mr. Arnold made to become a parent. Mr. Arnold hasn't seen his child since the child was 3 months old, even despite the fact that Mr. Arnold had the ability in 2016 through 2020, because the petition was filed in January the 13th of 2021. Mr. Arnold filed nothing. He didn't participate as a parent. He decided that, in essence, in 2018, I'll send one Facebook note, and that became too much for him. So we're here
There was
based.
some evidence that he made more outreaches than that.
The court found that he had made one potential issue of a happy birthday card, that he had reached out on social media, but that as a result of the social media, he decided that he didn't want to participate anymore and to pursue a relationship with his child. There's also a note in the decision of the magistrate that Mr. Arnold hadn't seen his son since he was 3 months old. So I appreciate the question, Judge Bergeron. We're here based upon the fact that under statute, under 3107.07A, that once a petition is filed, that the court has the ability to look back to the actual initial placement of the child, which would have been September 29th of 2015, and that 1 year preceding that, 1 year preceding that, which would be September the 29th of 2016, all the way back to September 29th of 2015, which the court took into consideration regarding the issue of consent. The court also took into consideration the issue of consent regarding that Mr. Arnold decided not to file an objection to the decision or to the petition, as well as also from January the 13th of 2020 all the way up to January the 13th of 2021. Opposing counsel wants to state that the court abuses discretion by not considering all the factors. The court goes through and makes a thorough analysis of all the factors that the court believed were pertinent to this matter. It's interesting to note that opposing counsel starts by stating that one factor that they strongly consider is the issue of the least detrimental alternative to the child. Under 3107.0161C, the burden actually falls on to the person who is contesting the adoption to prove that that's not the least detrimental alternative. In essence, that they have to prove that the safety of the child or the placement of the child is not the least detrimental to the client. In fact, opposing counsel and Mr. Arnold do the exact opposite. They give all the applause in the world to my client. She's a great mother. She takes care of the child. The house is suitable. There's no issues. As a result of that, that is one factor that they, in essence, put into play that actually goes against them. There are 11 factors in 3107.161, and the court correctly alludes to all of those, talking about the safety of the child. One of the questions before opposing counsel was whether or not this child had had something involved in his head or had been coached, in essence, in which to state that he doesn't want to have a relationship with this child or with his father. This child has grown up with my client since 2016. This child is an articulate child and is well-spoken.
How old was the child at the time of the in-camera review?
The child would have been 10 years old, Your Honor. Thank you for the question. This child can articulate and present to the court what he sees, what he observes, what he knows. This isn't a matter about being coached. It's about a matter of reality of what he understands to be the case.
Didn't he reach out at some point was it to his mom, or I thought he reached out to his parents at some point?
Thank you for the question, Presiding Judge Cross. I appreciate that. He reached out one time on a cell phone that actually had his mother's number in it and reached out through FaceTime or through FaceTime application. And that, through the testimony, I believe that conversation was either 11 minutes or 13 minutes.
And how old was he when that happened? Approximately.
I believe he would have been 9 at the time, Your Honor. I think he had had a cell phone that was provided by my client, but that he had a access to a cell phone, contacted his mom, and had about 11 or 13-minute discussion with her, Your Honor.
So that was about a year before he then says that he doesn't want to have a relationship with her?
If the issue is that he is at 9 o'clock, or not at 9 years old, yes, it would be 1 year approximately prior to that. If that is the understanding, that certainly doesn't rise to the level of de minimis contact, Your Honor. And the court went back and pursued all of that information as far as what constitutes de minimis contact. The idea of de minimis contact, the idea of financial payments and maintenance made to the child is in regard to the issue of consent. Opposing counsel doesn't raise the issue of consent in this argument. He raises the issue of the best interest of the minor child and states that the court abused its discretion in issuing the best interest of the minor child and also failed, that my client failed to meet the burden that is required under 3107.161.
So the issue of consent has basically been waived at this point.
That is correct, Your Honor. I thank you for the question, Judge Bach. The issue with that is that consent has been waived at this point. But also, if the court went through the entire argument under statute, even if consent wasn't necessary at that point under the statute, because opposing counsel's client failed to raise an objection, it would also be consent to the adoption. I make reference to that in my first argument, stating that in essence, he tacitly consents to the adoption by failing to raise an objection. The fact that opposing counsel, that the mother failed, actually filed a consent objection, but has now not filed an appeal, that issue becomes moot at this time, Your Honor. Thank you for the question. I appreciate that. We're looking at a child who is 11 years old, who in the last 2.5 years of his life has been, in essence, a pawn between the mother and the father trying to get access to the child. That is seen in the fact that in May of 2021, 5 months after the fact the petition for the adoption being filed, they actually filed in juvenile court. Mother filed in June of 2021, which raises to the concern that presiding Judge Krause has actually stated that this child may be taken away. The idea of having this child have permanency is what the adoption is all about. It's about stability. It's about permanency. If the court overturns the judge's decision in this matter, then we're left with all these alternatives to what can happen. This child is safe. He appreciates where he's at. He understands that Ms. Schroeder is his mother. That my client calls her mother. She has stepped up to take responsibility of this child. She's been through 2 objection hearings. She's been through numerous hours of testimony. And this simply goes to the fact that at any point in time between 2016 and January 13th of 2021, even if it had been January the 12th of 2021 that opposing counsel's client filed in juvenile court, this petition never could have happened because the juvenile court would have had to dispose of it first. It's the lack of any kind of being present in the child's life. It's an act of just, I don't want what's best for my child. That's really what this boils down to.
He wants to be part of the child's life. He wants the child to know him and his side of the family. He's not saying he doesn't want what's best for his child. He thinks what's best for his child is that he has some sort of involvement in his child's life.
And I thank you for the question, Presiding Judge Krause. That's correct. But the court has already taken that step in saying the idea of adoption is permanency. And we understand that this child and that the parent of this child may not have a relationship until after the child turns 18. And we're okay with the fact that the parents' rights are going to be severed. But in the interest of the child is not about what is in the best interest of the parent. It's about what is in the best interest of this child. This child has grown up with my client. He's grounded in what he's supposed to do. He knows where he's supposed to be. It has always been about, what can I do now? What can I do now? And the reality of the situation is it's too late. The court has very clear guidelines on what it must consider under the statute. Opposing counsel not stepping up until 5 months after the fact to even have a visitation is problematic. The fact that the mother didn't step up until June of 2021, until 6 months after the petition was filed, is problematic to her. The court has considered all of these factors. The court has looked at what this child has stated in camera interview and says, listen, I know I may not have a relationship with my mom. That doesn't mean that I don't want and wish her the best. It just means that I don't want it. And the child states, at some point I may. But we have to decide, the court has to decide what is in the best interest right now of this child. And this child undoubtedly wants to be adopted. He doesn't know his father. There's testimony in that. It's not about whether or not it's a race issue or this, he can make it so that the child has more knowledge or more love in the family. It's about what is in the best interest of the child. And the court goes through all those factors and says, listen, even regarding the fact that now father may be in a better spot, does not outweigh the fact that this child needs permanency and stability and wants to feel safe and secure knowing that at any point in time there's no matter that can be raised in a juvenile court regarding custody, change of circumstances and things like that. And the court even states that, even though right now they may not want to do that, even though right now in the testimony they're saying, we would never do that, we would never do that. The court weighs into that factor and says, but they may. Adoptions are about permanency, and that's what has to be considered in this case. It's not about what may happen. It's about what is happening now and what could have transpired and happened before. That is what has led us to my client filing her petition. She gave ample opportunity. And in the regards to that, he can do, the opposing counsel's client can do what he wants to do to believe and make himself better. The mother can do what she wants to do to make herself better. But in reality, at January the 13th of 2021, anything that happened after that point is irrelevant to whether or not the permanency of the adoption and the granting of the adoption should go through. The court considers the factors. My client has met all of the burdens of proof. The GA, or the report from the in-camera interview shows all of those factors that have been weighed. And the court still says, we believe that severing the relationship between the father and the minor child is more paramount to the child's best interest than going forward and having a relationship. It doesn't prevent him from having a relationship with a child at 18. It just means that for the next 6 years, that the child is under the care and custodialship of my client. That's where we're at. That's where. If there are no more questions, I will sit down. But I just want the decisions that brought us here are the decisions that brought us here were based upon the lack of decisions and the father stepping up in the 6 years prior to that. Thank you, Your Honor. Appreciate it.
Thank you. Mr. Whitfield, you have 4 minutes.
Thank you. The statute is supposed to be strictly construed to protect the rights of parents. That goes without saying. That's also.
Mr. Whitfield, I mean, these cases are really hard for us because we just see the record. We haven't seen the child. We haven't, seen any of the testimony in person. But there is a focus on the best interest of the child and not the best interest of the parent. And I think that's what's really difficult in some of our cases is the parent may be doing great work, may be totally admirable, but we have to focus on the best interest of the child. And so how is that an abuse of discretion here, the trial court's finding?
Because I think if the best interest of the child, and just generally speaking, the more people, the more folks who love, care, nurture a child, the better off that child's going to be. And what we're doing here today is cutting off, and I say one side of the family, but we're cutting off two parents from their child. And we're cutting that child off from two biological factors, two parts of him. And so if we don't have to do that, then why are we doing that? And we keep trying to say, and I hear counsel say, well, he had time, he should have done this, and this should have happened, and this should have occurred. When he thought this child was with mom and mom's family. When he found out, the way he found out that the child was with someone else is when he was trying to figure out what's going on. When can I see my son? He found out just kind of, not to use too much slang, but kind of on the humble. No one notified him. He didn't even know that there was court proceedings. So when he found that out, he reached out. Hey, I want to see my son. Hey, thank you for taking care of my child. He says that. That's in the messages. Thank you. I would like to see my son. You're not seeing your son. No. He was thwarted from all of his attempts from seeing his child. You can't see him. You're not going to see him. You're not his father. Where have you been? You're a deadbeat. You're this, you're that. He backed up because he didn't want conflict.
Was this after he had gotten clean?
This is after he had been clean, I think, for some time, a short period of time, but he was in a much better place.
Okay.
When he wasn't clean and he wasn't using, he didn't want to interrupt his child's life. He didn't want to put himself in that situation when he wasn't prepared, when he wasn't going to be an asset, when he wasn't going to be of value to this child. And when it's time there and he's rejected, he said, okay, well, let me take care of my child financially, because nobody can stop that. Let me do what I need to do, even though I can't see him, even though I'm not seeing him. And I can't sit here and tell you why he didn't run out and file for custody or why mom didn't file for custody. But you just noted the child reached out to his parent. And it says out of curiosity, I think, in the magistrate's decision. So how do we know he's not going to be curious in 11 and 12 years, or 11 years, 12 years old? Like, how do we know he's not going to have questions about his ethnicity at 14 or 15 years old? Like, why do we need to cut that off? Why do we need to cut off that option? Why do we need to cut off a possible opportunity? We don't need to cut that off. That's why it's not the least detrimental alternative. That's why it's not in his best interest. If you go through the factors, the duration of separation from the child's interaction with his parents, it was cut off. He wasn't allowed to interact with his child. The period of time of separation grew and grew and grew because of the actions of the petitioner. She's a great provider, but she wasn't trying to foster a relationship between his child and his parents. That never took place. And the courts are designed to set up and protect these children, protect children in their best interest. Because I think, as the court alluded to, his best interests are what is concerned. He has a right to his parents just as much as the parents have a right to him. And that's what the statute, that's what everything is designed to protect. That's why it requires strict assurance. And that's not what we have here. There's an option available. That option is to deny this adoption. Keep the child where the child is in a safe, stable environment. Mr. Epley always says they're making our point for us. My client continues to heap praise upon this woman because she took care of his child, and he appreciates that for life. He just wants to supplement. He just wants to be a father. And he can be a father if the court reverses the decision below.
Thank you. Thank you for your arguments this morning. The case is submitted, and we will issue a timely decision. And that concludes our session today. Thank you all very much.